So as a review of your hospital liability versus medical negligence and malpractice, here in your slide, you will see a column uh, that shows to you the differences between the three concepts. So what's the difference between hospital liability, medical malpractice, and medical negligence? So let's start from the rightmost column because I think this is the most simple one because this is closer to us as doctors, no? Because we practice medicine. So medical negligence, ito yung nangyayari when you as a doctor or any medical professional who have a patient doctor relationship or have a duty of care to your patient to provide care not to the patient does not comply with the standard of care which is expected in each case. So therefore, medical negligence is simply not providing the standard of care that is expected of you as a medical professional. So in other words, medical negligence happens every day because I'm sure every day there are doctors due to various reasons, whether public or private hospitals, they screw up, whether it's because they're tired or because of the lack of knowledge or because of a difficult patient. These things happen, no? Medical negligence can happen to any of us, no? Uh, Simply because not all times we are able to provide the adequate standard of care uh, to all our patients that we see. However, how is it different from medical malpractice? So medical malpractice happens because when you have medical negligence, no? There's a deviation from the accepted standard of practice in a medical community. Plus, so aside from medical negligence, you have now the element of injury or death. So once you cause injury or death to the patient due to the medical error of the doctor or any medical personnel, that will constitute medical malpractice. So medical malpractice is a result of medical negligence leading to death or injury to a patient. So this can become now a form of uh, legal problem for doctors because you now have caused injury because of your medical negligence. For most of us, our concern is medical malpractice. However, it is also important to note that aside from medical malpractice, there's also what is called hospital liability. Now, in your previous sessions, you know that a hospital cannot practice medicine because it is not a juridical uh, entity that can practice medicine. However, it's still liable to ensure quality of care to all the patients that goes through its facility. Therefore, hospital liability happens when the hospital violated the accepted standard of care by not requiring, so remember this, adequate supervision to all of its medical practitioner, correct? So there's the element of supervision, not giving safe, adequate facilities. So remember the, the number one duty of hospital to give safe, adequate facilities for the practice of medicine and deviating from its own policies in ensuring quality of care for its patients. So that's number four, duty, which is appropriate rules and policies that will ensure adequate care for the patients. So when the hospital fails in any of these instances, that hospital now becomes liable to whatever injury or death that's a consequence of the failure to live up to its duty as a hospital. So let's take a look at the specific form of hospital liability in the Philippines. So hospital liability is based on quasi delict and vicarious liability under Articles 2176 and 2180. So when we say quasi delict and vicarious liability, you're not the direct agent that caused the harm. So you are at best an indirect contributor to the injury or to the cause of death of the patient. But even though you are not the direct agent, because you have vicarious liability or you have liability, you can still be held liable under the law of the Philippines, especially under Articles 2176 and 2180 of your civil code. So over the years, at least 8 different bills with different authors have been filed in the Senate and the lower house seeking to legislate and criminalize medical malpractice. Uh, but not one of the bill has become law. So at this point of time, instead of a medical malpractice bill, we go back to the revised penal code, we go back to the civil code, we go back to the existing laws to prosecute uh, hospitals and doctors in terms of their liabilities to patients. Nevertheless, there have been various civil groups whose main advocacy is to pressure Congress uh, to legislate medical malpractice laws. Before, only physicians and those directly involved in the medical professions were made liable for negligent acts or omissions causing injury to patients. It was only when the case of Ramos versus CA decided in 1999 when a hospital was impleaded as dependent in a medical negligence case. So before, it was only the staff. It was only the doctors or probably nurses or pharmacists or other medical personnel that were held liable for negligent acts or for medical malpractice. But in the late 1990s, a landmark case also now made hospitals liable uh, for injury or death of patients. And we'll take a look at that later on. So the case of Agana, um, this case which was prosecuted is I think the one that was a landmark case, no, that allowed hospitals to be included as uh, defendants in the medical malpractice case. Um, this is the summary, no, of how the hospital was established to be liable for the death and injury to patients due to negligence that happened within its walls. So the facts of the case include the following. No? Enrique Agana told his wife, Natividad Agana, to go look for the neighbor, Dr. Ampil. So Dr. Ampil was a surgeon of Medical City, which we know was a big uh, chain of hospital in Metro Manila. It's a prominent and known hospital. And as a result of the operation that Natividad Agana underwent in Medical City, Natividad suffered injury due to because there were like some gauze that were left in the body inside her cavity after the operation. So they lost two gauzes. The nurses reported the missing gauze. They tried to look for the missing gauze, but the gauze were not located. So because they were not able to find it, probably the field was bloody, just dark. So they need to close the operative site. So what they did was they repaired the structures and everything. They secured it back, and the patient went home. However, uh, they were not able to retrieve the gauze. So despite the report of two amazing gauzes after the operation, the hospital, PSI, which was the owner of the medical city, did not initiate an investigation. So they did not, initiate due diligence, despite the fact that the nurses during the OR reported that there were two missing gauzes. Because, of course, as nurses, you know that there's account that happens after surgery to ensure that the equipments are complete, the all the gauze that were used and all the things that were used are accounted for. So the question is whether PSI or the hospital should be liable for damages, which is called tort. No? Are they liable for the damages that was a result of leaving the gauze? So the decision of the court was yes, the hospital was liable, and yeah, they were uh, uh, the plaintiffs were awarded 15 million plus 12% interest until full satisfaction. So the court said that while PSI had no power to control the means or the method by which Dr. Rampil, who was the surgeon there during the time, conducted the surgery on the plaintiff, they had the power to review or cause the review. Because no, number three, responsibility of hospital, supervisory powers over all doctors in its facility. So PSI has the duty to tread on as captain of the ship for the purpose of ensuring the safety of the patients availing themselves of its services and facilities. And also, PSI defined its standards of corporate conduct. And even after her operation to ensure her safety as a patient, uh, they will still have a responsibility to ensure that the patient uh, was safe. So it was not just limited to recording, no? So the responsibility of the hospital was not just limited to recording and documenting that there were two missing ghosts that were not uh, uh, located during the surgery. It also extended to determining Dr. Ampil's role in it, bringing the matter to his attention and correcting his negligence. So therefore, they should have reached out to Dr. Ampil and said, Dr. Ampil, I think you should follow up your patient and ensure that you do due diligence and look for that gauze. And if you need to reoperate to ensure that the patient is safe. So admission by itself, no, like they admitted that they were able to locate the cause. That's not by itself bar, no, at that time the corporate responsibility of PSI, no, even though at that time it was not yet in existence when the plaintiff underwent uh, surgery. So Dr. Ampil was found guilty of medical negligence, and PSI was guilty of corporate negligence. And liability unique to this case is because of the implied agency and admitted corporate duty of the hospital. And the final decision of this case happened 26 years after the surgery. So that's how long the litigation happened. And Dr. Ampil's status could no longer be asserted um, at that time. All right, so let's have another comprehension check before we proceed. So I hope you are now ready to go to slide.com and answer the question. True or false? All hospitals can be sued for liability. True or false? Okay, so 15 answered. 52% said false. The correct answer is yes. It's false. It's correct. So not all hospitals can be sued for liability. And I think this was already mentioned in the previous sessions. Not all hospitals may be sued in the Philippines because hospitals in the Philippines can either be run by the government or by private individuals or corporations. And some hospitals, in fact, are called charitable hospitals. They are not for profit hospitals. They run based on charity, and there are limitations to when they can be sued by plaintiff. In general, government hospitals are immune from suit because there is a general doctrine that the government cannot be sued unless it permits itself to be sued. So the basis of immunity is the recognition that government charity hospitals are performing a governmental function. So it's performing a state function uh, uh, as part of the responsibility of the state to provide adequate care for its citizens. So because of that duty of the hospital to provide adequate care, the government runs these hospitals, no, as a charity. We don't pay. You're not supposed to pay in government hospitals. Because of this function, said hospitals will fall within the rule that the state cannot be sued without its consent. On the other hand, charity hospitals cannot also directly be sued uh, because once you go to a private charitable hospital, it's understood that you sign a waiver, uh, when you avail of the services, unless there are culpable existing laws that are violated by the event that happens in the hospital. Okay, another review check, another question, opportunity for you to get some more points. What are the applicable doctrines in hospital liability? So you have doctrine of corporate negligence, doctrine of apparent authority, doctrine of vicarious liability, or all of the above. So the correct answer is all of the above. Yeah, correct. No? It's all of the above. So applicable doctrines, in hospital liability include doctrine of corporate negligence, doctrine of apparent authority, and doctrine of vicarious liability. So kanina, we talked a little bit about the doctrine of corporate negligence, which was used as a basis for uh, uh, the case that we discussed earlier about the doctor who left two gauzes in the body of the patient, and the hospital was also uh, deemed liable for damages, no, to the patient. So corporate liabilities are those arising from the failure of the hospital as corporations to provide necessary accommodations and facilities or observe the standard of conduct to which the corporations will conform. So kanina, as I mentioned earlier, the hospital failed to supervise adequately, respond to the report that there were two missing gauzes uh, after the surgery, and they did not monitor Dr. Ampil so that Dr. Ampil would follow up on the patient, and therefore, as a result, they were guilty of negligence. No? So they were liable for the harm done to the patient. So example of corporate liability will be failure to furnish safe and well-maintained buildings and facilities. So pag merong air conditioning unit doon sa hospital, tapos nahulog siya, this happens many times, no? Nahulog yung cover or nahulog yung aircon itself, tapos nakadagan sa pasyente, nag-suffer ng injury yung patient, or at worst, namatay. Or nag-slide yung patient doon sa sa tawag dito sa room ng hospital dahil the hospital did not put adequate safe safety rubberized mat, nag-slide, pwede din siyang maging culpable, no, for liability. So you need to provide safe and well-maintained buildings and facilities. So failure to provide safe and reliable equipment. So gumamit ng ventilator, yung ventilator hindi well-maintained, and as a result of using that uh, ventilator, it caused the ventilator itself, caused the death of the patient, established that it was the ventilator, caused the death, either because it malfunctioned or because um, the oxygen tank was not properly filled up, etc. They will be liable for the damages to the patient. So failure also to make careful selection review supervision. Ito na yung sinasabi natin kanina, supervision of independent physicians who are permitted to practice in hospital. So kahit consultant siya, kahit hindi siya empleyado ng hospital, you still need to exercise adequate supervision of your independent physicians. So kahit independent contractor siya, hindi siya pinapasweldo ng hospital, kahit consultant siya, katulad kay Dr. Ampil, consultant siya, surgeon siya ng sa hospital. Supervision implies that pag mayroon silang nakikitang pagkakamali o problema doon sa surgery, they should make sure that they will call the attention of the doctor to make to allow the patient to have the quality of care that they require. No? So the doctrine of corporate negligence is a legal doctrine that holds healthcare facilities such as hospitals responsible for the well-being of patients. So if the hospital fails to maintain a clean and safe environment, hire competent and properly trained employees, oversee care and implement safety policies, it can be held liable for any harm to patients. So ito yung summary natin ng corporate negligence. So under the doctrine of corporate liability, the hospital can be found liable even if the surgeon was an independent contractor. So corporate negligence provides for a form of direct liability that subjects a hospital to civil liability for its own failures to adopt appropriate policies and procedures to protect the patient. So the case kanina, the court ruled that the hospital should pay the patient 50 million plus 12% interest as long as the as long as the the penalty was not being paid. So it is an accruing interest. So the longer they don't pay the patient, the more they have to pay the patient. So it's a civil suit for damages. On the other hand, a vicarious responsibility or vicarious liability refer to the liabilities of hospitals for the acts of employees provided under Article 2180 of the Civil Code. So the Civil Code states that under Article 2180 in relation to Article 2176, that the hospitals have vicarious responsibility based on respondent superior or under the principles of let the master answer. So if the employees committed negligence, therefore the hospital is liable also to be charged for negligence because of vicarious liability. However, Article 2180 requires sine qua non, no? Or we need to say as an essential element, no? Essential requirement, the existence of an employer-employee relationship. So they rely on proving the existence of an apparent agency. So therefore, the hospital to be found vicariously responsible for the negligence of its employees, of any staff in the hospital. It should be established that there is an employer-employee relationship. So for example, a doctor or nurse or pharmacist should be employees of the hospital in order for the hospital to be liable vicariously. So as I mentioned earlier, there are three distinct legal relationships that are established when a patient goes to hospital. So between the doctor and the patient, between the hospital and the patient, and between the doctor and the hospital. And this relationship are separate from each other. Therefore, they have different forms of liability. Each other. So in the Philippines, employer-employee relationship established based on the primary test of hiring. So first, the hospital hired the the staff. Firing means to say the hospital can actually fire the staff from its role. So mean to say it can stop that person from working in the hospital. Third, it is paying wages. Mean to say there's a salary that's being given to the employee, and there is control. So the hospital exercises control over uh, the staff in the hospital. So it has been consistently held that in determining whether an employer-employee relationship exists between the parties, the following elements must be present. First, there should be selection of the staff. So there should be like a hiring process where you select from among the candidates, potential candidates who can, go and become part of your staff, and a contract to engage in services. So there's a contract of engagement in services. Also, there is payment of wages or pinapasweldo. There's also the power to hire and fire, and there's also the power to control not only the end to be achieved, but the means to be used in reaching such end. So this was established in jurisprudence by the case Ramos versus C, Court of Appeals, that was established in the 1980s. So in general, hospitals are not liable for negligence of an independent contractor or physician. So generally, any doctor or consultant who is negligent because he's an independent contractor, the hospital is not liable for that doctor's negligence, except except where there is the doctrine of apparent authority that is working or that's present. And what is the doctrine of apparent authority? So, and in the case of Nogales versus Capital Medical Center, this was established where a hospital can be held vicariously liable for the negligent acts of a physician providing care at the hospital, regardless of whether the physician is an independent contractor, unless the patient knows or should have known that the physician is an independent contractor. So if the patient, based on reasonable assumptions, saw the physician or the doctor as, you know, part of the hospital, unless there's a clear understanding that the doctor is an independent contractor, the hospital will still be held liable due to doctrine of apparent authority. So this is the ruling that was based by Nogales versus Capital Medical Center. So there are cases where a person may be deemed an agent of a principal, so an agent, so like a doctor, of a principal, like a hospital, based on the latter's act of floating the former with apparent authority. So if your authority as a doctor to practice in that hospital is due to the authority given to you by that hospital, then there is apparent authority. So under these circumstances, the principal cannot be permitted to deny the authority of such a person to act as his or her agent to the prejudice of innocent third parties dealing with such person in good faith and in the honest belief that he is what he appears to be. So that is the ruling of the doctrine of apparent authority. So for a hospital to be liable under the doctrine of apparent authority, a plaintiff must show that first the hospital or its agent acted in a manner that would lead to a reasonable person to conclude that the individual who was alleged to be negligent was an employee or an agent of the hospital. So any reasonable person using his reason, using his normal way of thinking, would be able to conclude that based on the action of this individual, that he was an agent or employee of the hospital. So that will also establish the doctrinal fundamental. Also, where the acts of the agent creates the appearance of authority, the plaintiff must also prove that the hospital had knowledge of and acquiesced in them, or approved these acts of the agent. And the plaintiff acted in reliance upon the conduct of the hospital is consistent with ordinary care and prudence. So these elements are what can make hospital liable under the doctrine of apparent authority. So an example of a case that was established hospital liability due to the doctrine of apparent authority was a case of Nogales versus Capital Medical Center. So Rogelio and his wife chose Dr. Estrada to handle Corazon's delivery, not only because of their friend's recommendation, but more importantly because Dr. Estrada's connection with the reputable hospital. So CMC is a well-known hospital in Manila, in Quezon City. And doctor star is granted by CMC staff privileges and extended medical staff and facilities. Also, when Rogelio signed the consent form in behalf of his wife who was undergoing the procedure, he signed a consent form for the procedure. He signed it on the paper that contained the letterhead of CMC. So that made it appear that Dr. Strada was actually an agent of the hospital because he was using the hospital's letterhead to uh, to let the patient or his uh, legal guardian sign the consent. So the letters did not mention that Dr. Strada was an independent contractor, physician, or a consultant of the hospital, and not an employee. So what happened was that during the operation, Dr. Strada was assisted by doctors of CMC. Unfortunately, the baby came out apneic, cyanotic, weak, and in injured condition, and had to be incubated and resuscitated by Doctors Enrique and Payumo, so probably the pediatric pending during that time. And also, Corazon's blood pressure kept dropping because of her vaginal bleeding. So, Himacel was administered, and she underwent immediate hysterectomy to control the bleed. However, eventually she died at 9:15 a.m. with hemorrhage postpartum. So as a result, the husband filed a complaint for damages against CMC. So the question is, was CMC vicariously liable for the negligence of Dr. Strada under Article 2180 in relation to Article 2176 of the TVP? So the court ruled that Dr. Strada is an independent contractor. So yes, the court said, okay, Dr. Strada is an independent contractor. He is not an employee. So there's no employer-employee relationship between Dr. Strada and applying the control test. There is no evidence to CMS's exercise of control over Dr. Strada's treatment and management of Corazon's condition. The patient was under the exclusive prenatal care of Dr. Strada because the patient was the patient of Dr. Strada. So CMC merely allowed Dr. Strada to use its facilities when Corazon was about to give birth, which CMC considered an emergency. So under the doctrine of this, under the test of control, no, and also having employee-employee relationship, it established that Dr. Strada is an independent contractor. However, even if Dr. Strada is not an employee of the hospital was still ruled to be liable vicariously. So vicariously liable under the doctrine of apparent authority. Ito yung mali nila because they gave the appearance to the patient and to his guardian, to her guardian, that Dr. Strada was an agent of the hospital. The doctrine of apparent authority is an exception to the general rule that the hospital is not liable for the negligence of an independent contractor physician. So the hospital acted in a manner that would lead a reasonable person to conclude that the individual who was alleged to be negligent was an employee or was an agent of the hospital. So the act of the hospital, in the case of CMC, giving Dr. Strada staff privileges and extended medical staff and facilities is enough reason for the spouse to believe that Capital Medical Center had authority over Dr. Strada. So that was the reason why the hospital was held liable under the doctrine of apparent authority. On the other hand, Ramos versus CA was a case involving Erlinda Ramos, a 47-year-old woman, normal, except for experiencing occasional pain due to the presence of stone in her gallbladder. So she had gallbladder polyp due to gallstone. She was advised to undergo an operation for its removal. So the results in examinations she underwent indicate that she was fit for her. So she was still cleared for the operation. So CP clearance okay. She and her husband Rogelio met Dr. Hosaka, one of the dependents, who advised that she should undergo cholecystectomy. Dr. Hosaka assured them that he will get a good NS. At 7:30 in the morning on the day of the operation, at De Los Santos Medical Center, Hermenda Cruz, the sister-in-law of Erlinda, and the dean of the College of Nursing in Capital Medical Center was there to provide moral support. And Dr. Perfecta Gutierrez, the anesthesiologist, was there to administer the anesthesia. So, 7:30 pa lang nung nandun na yung uh, support. However, Dr. Saka arrived only at 12:15 p.m. and Hermendez saw Dr. Gutierrez intubating the patient and heard the latter say, ang hirap mag-intubate nito, mali yata ang pagkapasok. Oh, lumalaki ang tiyan. Hermendez saw a bluish discoloration of the nail beds of the patient. So, cyanotic patient, she was not getting adequate airway. And she heard Dr. Saka issued an order for someone to call Dr. Calderon. So, Dr. Calderon was another staff hospital. Dr. Riven placed the patient in the Trendelenburg position, wherein the head of the patient is positioned lower than the feet, which indicates a decreased blood supply in the brain. So they were doing an emergency procedure, not to urgently provide oxygenation for the patient. Camila knew and told Rogelio that something wrong was happening. So Dr. Cordon was able finally to intubate the patient. Erlinda was taken to the ICU and became comatose, unfortunately. So Rogelio filed a civil case for damages. So the issue is whether or not the hospital is liable. So the ruling was that hospitals fire, and exercise real control over their attending and visiting consultant staff. So while consultants are not technically employees, so see, they are independent contractor, they are consultants, a point which respondent hospital asserts in denying all responsibility for the patient's condition. The control exercise, the hiring, and the right to terminate consultants all fulfill the important hallmarks of an employer-employee relationship, with the exception of the payment of wages. So in assessing whether such a relationship in fact exists, the control test is determining. So, okay, independent contractor siya. Okay, hindi siya pinapasweldo. Okay, hindi siya hinire as a staff. However, the question, do the hospital have control over the doctor? According to the basis of foregoing, the court ruled that for the purpose of allocating responsibility in medical negligence cases, an employer-employee relationship in effect exists between hospitals and their attending and visiting physicians as long as the hospital have control over these visiting physicians. So the basis for holding an employer solidarily responsible for the negligence of its employees found in Article 2180 of the Civil Code, which considers a person accountable not only for his own acts, but also for those of others based on the former's responsibility and the relationship of patria potestas. So what is patria potestas? So this is a Latin term which says the power, the responsibility of the father, because the father has a power and therefore that power gives you responsibility over your children. So such responsibility ceases when the persons or entity concerned prove that they have observed the diligence of a good father of the family to prevent damage. So they are not responsible if they're able to show that they exercise due diligence of a good father of the family to prevent damage. In the case that we just discussed, respondent hospital, apart from the general denial of its responsibility over respondent physicians, failed to provide evidence showing that it exercised the diligence of a good father of a family in the hiring and supervision of the latter, of the doctor. It failed to produce evidence with regard to the degree of supervision which it exercised over its physicians. So, dapat napakita nila na mayroon silang ginagawang adequate supervision over its physicians. So, this neglect, no? Neglecting to offer such proof or proof of similar nature, Respond Hospital therefore failed to discharge its burden under the last paragraph of Article 21. So having failed to do this, Respondent Hospital is consequently solidarily responsible with its physicians for Erlinda's condition. Alright. So now that we've established how the doctrines that are operative in assigning responsibility for liabilities of physicians, it is not only liable for the actions of its employees, it's also liable for everything, for all the units that are operating in the hospitals, and it includes its ancillary services or support services. So whenever the hospital administration enters into contract with a partnership of physicians, for example, to run the emergency room, because the emergency room can be subcontracted to a group of physicians, for instance, the medical staff therein are not considered employees at the hospital. So therefore, liability for negligence for any medical emergency is shifted to the medical partnership. So the partnership assumes responsibility because it took over the control of the emergency room services. So courts have held that even if contracts specify that physicians will be considered independent contractors, the hospitals are still responsible for their actions if they exercise control over them. So the key word here is control. No? And patients are not bound by secret limitations contained in private contracts between the hospital and the physician. So kahit merong sariling contract agreement between the hospital and the doctors, they are not bound by that secret limitations. All right, let's have another knowledge check and see if we can get some points here. So go to slide.com and see um, if you can join this question. What are the two aspects of emergency care in the emergency room? Examination of patients to determine condition of emergency needs, immediate admission of patients, performance of elective routine procedures as scheduled in advance. None of this. So what is the correct answer? Okay. So yes, correct. Examination of patient to determine condition and health emergency needs is one of the two aspects of emergency care in the emergency room. Performance of elective routine procedure is not. It's performance of emergency procedures or uh, actions, not scheduled in advance, but emergency procedure. So that is why this is wrong. So two aspects of emergency care includes examination of patient to determine his condition and the need for emergency medical procedures. And number two is performance of the specific medical or surgical procedure, which are required without delay. So this is an emergent condition without delay to protect the patient's health. So these are the two aspects of emergency care: examination and performance of specific medical surgical procedure. So liability in the emergency room as an ancillary service may arise from the following: no? Failure to admit if the patient needs to be admitted and you are not able to admit the patient. Failure to examine or treat, that's what we have mentioned earlier. Negligence in the application of management procedures, and anything of those nature will lead to negligence in the emergency room services. Another ancillary service is the maintenance of medical records. So medical records are important as a medical document, as a legal document. And the reason why we keep medical records is, of course, it's for convenience and necessity in consonance with the purpose that we have enumerated. Primarily because we wanted to provide quality of care and we wanted to provide adequate supervision to our doctors. It is also required by law. Hospital may be held liable for injury resulting from breach of duty to maintain accurate records. So destruction of records is an evidence of negligence. If anybody destroys medical records, it is an evidence of negligence. And an alteration in a medical record may create suspicions of intent to establish a defense. And such alterations, if seen, may be a proof of negligence. Also, removal of a certain portion of record may raise suspicions, no? That that person they remove deliberately in order to suppress. Okay. All right, so let's have another question for your knowledge check this afternoon. So medical records are owned by the patient, by the doctor, or by the hospital. So who owns the medical record? So the owner of the medical record is what's you're correct, no? The hospital is the owner of the medical record. Specifically, it is the owner of the paper on which the medical record is printed. So because it usually comes from the supply of the hospital, then it's the ownership of the hospital. So it's not the patient who owns it, it's the hospital. However, ownership of the medical record means that it is just primarily custodial for the hospital. So the guardian and owner of the medical record is the hospital. But ownership of the medical record is a limited one in the sense that it is not absolute. And it's primarily considered primarily custodial. Ibig sabihin, you're just the caretaker of the record in behalf of the patient. But it's not also owned by the patient. But the patient also has a right to see the records, his own records. Also, remember that under existing laws, uh, we should keep these medical records confidential. So, for example, in the Code of Medical Ethics, we should not violate the confidential nature of the information contained within these medical records because this could damage reputations and violate the dignity of the person or violate his privacy, for instance. So never divulge confidential information or anything that may reflect upon the moral character of the person involved, except when it is required in the interest of justice, public health, or safety. Also, in the Comprehensive Dangerous Drug Acts of 2002, the doctors are required, no, to maintain and keep original records on transactions on dangerous drugs and or controlled precursors and chemicals. So the violations, no, have penalties ranging from 10,000 to 50,000 and imprisonment from 1 year to 6 years for failing to comply with maintenance and keeping up original records of transactions on any dangerous drugs. So an additional penalty is revocation of license to practice profession. Also, we have to maintain confidentiality of records. So aside from putting it into record, we should also protect confidentiality of records. So the judicial and medical records of drug dependents under the voluntary submission program shall be confidential and shall be used against him for any purposes, except to determine how many times before by himself or through his parents, spouse, guardian, relative within the fourth degree of consanguinity or affinity. He voluntarily submitted himself to confinement, treatment, and rehabilitation in training centers. Also under the rules of court, no, in section 21 rule 130, these are also considered as privileged communication. So a person authorized to practice medicine, surgery, or obstetrics cannot, in a civil case, without the consent of the patient, be examined as to any information. So as a doctor, it's protected information. So your doctor-patient relationship gives you a certain degree of confidentiality because that is a form of privileged communication. What happens, the communication between the doctor and the patient. So without the consent of a patient, he cannot be examined as to any information which he may have acquired in attending such patient in a professional capacity, which information was necessary to enable him to act in that capacity, which would blacken the character of the patient. So these are part of the jurisprudence with regards to medical record information. Now, there are some information for which no authorization is needed, including the name of the patient, the doctors, etc. All right, so let's have another question before we proceed. So who can access patient records for purposes of their work or research? Doctors, medical students, medical staff, or all of this? So yes, all of this. Doctors, even you, medical students, can access patient records for purposes of the work you're doing in the hospital or for your research, as long as appropriate permission is granted to you. So when requested by a patient or by someone who could act in his behalf, he could request for the records of his case. No? A patient can request his medical records. Also, the law, when the law requires such disclosure, uh, it can also be disclosed. And also when the court orders disclosure of such information based on legal proceedings. However, note that the attending physician has no legal right to determine who shall or shall not see the record. At the most, his approval or permission is only a matter of courtesy because he is not really necessary to get permission. So members of the resident staff, student, and the telemedical staff may freely consult such records as pertain to their work. Okay, let's now go to ambulance service. Ambulance service is another ancillary service in the hospital. So transport of patients to and from the hospital is an essential service of the hospital. So therefore, a part of its duty, the hospital must ensure that the ambulance will have minimum facilities required to answer the demand of an emergency situation that will happen during transport. However, the criminal liability of an ambulance driver is the same as that of any ordinary transport driver. So pag makaligis siya kalsada, if the driver of an ambulance kills somebody on the road because he was driving like crazy on the road, he will still be held criminally liable, even though he was riding an ambulance. However, local statute or ordinances may grant it the right of way. So, for instance, if uh, in the city they might pass a law or an ordinance granting rights to ambulance to have priority on the road, then that would allow them certain privileges right of way. But it is not, you know, automatic. It should be based on existing rules and regulations within that department. Also, ambulance service may be owned by the hospital or by private institutions independent of the hospitals. And ownership, of course, will mean who will be responsible for liabilities arising from the use of the service. Another ancillary service is the hospital pharmacy. So this is a place where drugs, the medicines, chemical products, and pharmaceuticals are sold. And hospital pharmacy will supply to the various units of the hospital. However, negligence can also happen. For instance, there could be mistakes in prescription, um, so filling of mistakes. There could be problems with interpretation of what's written on the prescription. So this can also constitute negligence. However, the prescription, once it is shown and given to the pharmacist, it's now owned by the pharmacist. Okay, so when the pharmacist use the prescription to dispense the medicine, once the patient surrenders that, or once it's given to the pharmacist now owns the copy of the prescription. Also, the pharmacist is required to display his certificate of registration at all times in the pharmacy. However, is the pharmacist responsible for the quality of the products, for example, the medicines in the pharmacy? The answer is no. As long as the drug is already prepared to be used, you know, once it goes to the pharmacy. So it is the manufacturer of the drug. As long as the pharmacist stored it properly and exercised due diligence in storing that drug in its appropriate setting. Also, the filling and refilling of prescription will depend on the orders, no, of the one who is prescribing such medications. Also, at all times, there should be record books for prescriptions so that it will be a record of all the prescriptions that has been filled up by the pharmacist in the hospital. And also, there's a prohibition against the use of secret codes, ciphers, or unusual terms in prescriptions. That's why in your pharmacology, you have been taught the standard symbols, standard language, standard format for writing a prescription because this is a standardized um, so that it will be easy for pharmacists all over the world to understand what you're writing. So going back to your medical records, we have already discussed this. Uh, we need to make sure that we are able to follow existing rules and jurisprudence regarding maintenance of records, protecting the privacy of the records, and also avoiding violations of the confidential nature of these records, and that we observe proper disclosure contents depending on whether the patient requested it or is it required by the law or is it there is a court order. Now, you might also be asked, for instance, how long do the hospital needs to keep the records? Because, for example, you have a lot of patients. So, for example, PGH is thousands and thousands of patients. Does it mean that it will, keep on those records forever? So, the statute of limitation will determine the length of time for retaining records. So, the statute of limitation refers to the liability, no? Because there's a certain period of time where uh, you can file a case pertaining to that medical record. So I think the statute of limitation will be about 6 years in many instances. So beyond 6 years, then hospitals can destroy those medical records. Finally, with regard to hospital liability, you also have your hospital securities and order. So one of the responsibility of the hospital is to maintain favorable environment conducive to patient comfort, peace of mind, and recovery. And if there is somebody who is violent or boisterous, whether it's a patient or trespasser, the hospital needs to maintain order. So they can call in the police to arrest, or they can themselves arrest without warrant, as long as the condition necessary for citizens arrest is appropriate there and present. I think this is the final question for you this afternoon. So please select all the ancillary services where hospitals may incur liability. So check all that are correct. So you can choose all that are correct. Okay. So yes, emergency room, pharmacy, ambulance service, and your medical records are all ancillary service except for your canteen. Canteen is not an ancillary service of the hospital. So Gurley, Annalyn, Michelle, Jasmine, Chris are our best performers for this afternoon in terms of the questions. Very good. Congratulations. So uh, we were also tasked to take a look at damages. So let's just do very quickly over this. So damages are your compensation that may be recovered for breach of duty or violation of rights. Recognized by them. So if a physician is found negligent of his services, he may be liable to pay damages for all direct, natural, and non-natural consequences of his acts. So the jurisprudence here is based on Articles 20 of the Civil Code. Every person who, contrary to law, willfully or negligently causes damage to another shall indemnify the latter for the same. Also, Article 2176, whereby an act or omission causes damage to another, thereby being fault or negligent, is obliged to pay for damages. So these are civil damages, no? Based on the civil law. So damages must be sufficiently proven by evidence. So to permit the court to determine how much it must be. So the proof must show the nature, extent, cause, and probable duration of injury so that you can, let's say, give the appropriate monetary compensation for the damages. So the doctrine of certainty of damages refers to the fact that damages must be certain both in its nature and in respect to the cost. So recovery must not be contingent or speculative to say, okay, it's based on probable damage. No, it should be based on actual damage, the certain damage that has been done. So the injured patient has the right to recover medical hospital expenses from the negligent professional, even though the patient has been indemnified wholly or partially by insurance company. So even though the 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 patient, if he has an insurance, no, is covered already by his own insurance, he can still sue the hospital or the doctor who did the injury. So that is part of the doctrine of certain damage. So types of damages in your textbook, you can take a look at this. It's your actual compensatory, you have moral, you have exemplary, you have nominal. These are the other types of damages. No? You have temperate, you have liquidated, etc. So your compensatory damages applied to medical practice will include death. No? So if you choose death based on Article 2206 of the Civil Code, the amount of damages for death caused by crime that caused by the election that is 3,000 pesos, 75,000, even though there may have been mitigating circumstances. Physical disability, loss of earning capacity, medical, surgical, hospital related expenses can be included in compensatory damages. Even the loss of service or support. Finally, even your funeral expenses can be part of your compensatory damages applied to medical malpractice. Also, moral damages can be uh, done, no? Can be given for those patients injured. Moral damages, according to Article 2217 of the Civil Code, will include physical suffering, mental anguish, fright, serious anxiety, besmirched reputation, wounded feelings, moral shock, social humiliation, and similar injury. Though incapable of pecuniary computation, moral damages may be recovered if they are the proximate result of the offense. Yeah. And another take note also of what is called the doctrine of avoidable consequences. When one person has true wrongful act caused personal injury to another, it is incumbent upon the latter to use such means as are reasonable under the circumstances to avoid or minimize the damages. The person wronged cannot recover for any item of damage which would have been avoided. So if the patient has been injured and then by his own negligence contribute to more injury, then he could not recover further damages subsequent to his negligence, not personally. Because if the patient could avoid the damage, but he did not avoid the damage or the consequences, and then he could not claim that against the one who did the original damage to him. So this is a doctrine of avoidable consequences, which is applicable to claiming for damages, especially in civil suits. I think that is enough for the day. It's already the 5 o'clock. So uh, thank you very much for listening, and